Ever lie to someone face to face, like look them dead in the eye and know they're going to figure it out?
Oh, I feel like everyone has that one moment. Mine involved a scratched car door and a "that must have happened in the parking lot" explanation.
Right. Now imagine doing that to FBI agents in your own living room while they're sitting on your couch, and you go upstairs and fabricate the evidence on your laptop, come back down, and email it to them on the spot.
While they waited.
While they waited. That's basically what we're talking about today in Abouammo versus United States. Oral arguments take place on Monday, March 30th. Listen to them here at the High Court Report.
And the Supreme Court didn't take this case because of the lying. They took it because of where the government prosecuted him for the lying.
Which turns out to raise one of the most fundamental questions in all of American criminal law. More on that in a second. Welcome back to the High Court Report. Today, can the government put you on trial in a city you never set foot in for a crime you committed in your own home? Before we get started, here's a quick reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get a nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report.
And look, if you're going to fabricate a document and email it to federal agents, the least you can do is subscribe to the podcast first. Questions about this case? Reach out to us via LinkedIn at the High Court Report.
All right, here's what you need to know. The formal legal question goes like this: whether venue is proper in a district where no offense conduct took place, so long as the statute's intent element contemplates effects that could occur there.
I'm lost.
So venue, in criminal law, that means the place where the government gets to put you on trial. And the Constitution actually protects that right in two separate places, Article 3 and the Sixth Amendment. Both say the government must try your criminal case where you committed the crime.
Now, that can mean they can bring charges in more than one state. Let's say you went on a robbery spree and robbed banks in Phoenix, LA, and Portland. The feds can probably bring charges for all in Arizona, California, or Oregon, but not anywhere. The feds can't charges against the bank robbers in Florida.
So the question is, Abouammo created a fake document in his house in Seattle. Can the government try him in San Francisco, hundreds of miles away, just because the FBI investigation he allegedly tried to obstruct happened to operate out of San Francisco?
And Abouammo says no. The government says yes.
And the government's theory, at its heart, is because you intended your conduct to reach our investigation in San Francisco counts as a proper place to try you.
So, intent alone can set the zip code for your trial.
That's the fight.
Okay, let's back up. Let's rewind to explain how Ahmad Abouammo ended up here. From 2013 to 2015, Abouammo worked at Twitter's San Francisco headquarters. Now, all of this is according to the federal government. They allege Abouammo's job gave him access to something called the Profile Viewer tool, basically a backdoor into private user data. Email addresses, phone numbers, IP addresses.
The kind of data that, in the wrong hands, could cause harm.
Which, and this detail matters, at least one Twitter user who got exposed reportedly faced torture and disappearance. This connects to a Saudi government official named Badr bin Sakhr. Abouammo repeatedly accessed private data of Saudi dissident Twitter users and handed it over to bin Sakhr.
And he got paid for doing this. 3 separate wire transfers of $100,000 each, plus a Hublot luxury watch that Abouammo later tried to sell for $42,000. So we're talking about $342,000 in payments for allegedly selling out dissidents to the Saudi government.
Abouammo also introduced bin Sakhr to a Twitter engineer named Ali Al-Zabara, who got even deeper access. Al-Zabara eventually fled to Saudi Arabia. Abouammo left Twitter in May 2015 and moved to Seattle to start a consulting firm.
And here's where things cascade. By 2015, the FBI's San Francisco field office opened a counterintelligence investigation into the whole Twitter situation. Then, in October 2018, 3 years into that investigation, the FBI learned the New York Times planned to publish a story that would essentially reveal details of the FBI's plans.
So, two FBI agents, Jonathan Kingsley and Letitia Wu, flew directly from Palo Alto to Seattle that same night. They wanted to interview Abouammo before the story dropped.
The article actually published the next morning, before the agents even got to his front door.
So, Abouammo already knew the story broke when these agents knocked. They identified themselves as, quote, FBI agents from the San Francisco office. He immediately asked if they came about the Times article,
And then spent several hours talking to them in his home, facepalm.
during which agents asked him for documentation supporting his claimed consulting work with Soccer. Abouammo said he had an invoice on his computer upstairs, went up, spent about 30 minutes, created a fake $100,000 invoice from his consulting company, backdated it, and emailed it as a PDF directly to Agent Kingsley's FBI email address. Double face palm.
While the agent sat downstairs, and here's the kicker. The PDF's own metadata showed it got created during that exact 30-minute window. That's how investigators figured out it was fake.
The fake invoice ratted him out.
A jury in the Northern District of California convicted him on the document falsification charge along with the other counts. He got sentenced to 42 months, which later got reduced to time served. But the venue fight survived the conviction. The Ninth Circuit, the federal appeals court covering California and the Northwest, upheld trial in San Francisco, and the Supreme Court agreed to take the case in December 2025.
So what does Abouammo argue?
His central point: everything he did happened in Seattle. He created that document in Seattle. He emailed it from Seattle. He never left his house. The federal statute he got convicted under, 18 U.S.C. Section 1519, part of the Sarbanes-Oxley Act passed after Enron, criminalizes knowingly falsifying a document with intent to obstruct a federal investigation. The crime carries up to 20 years in prison.
That's the document shredding law, post-Enron, post-Arthur Anderson.
Right. And Abouammo says that statute has one conduct element, falsifying a document. He did that in Seattle. Full stop. Intent doesn't move the geography. He points to a 1998 Supreme Court case, Cabrales versus United States, where the court refused to let Missouri prosecute a money laundering case that happened entirely in Florida just because the underlying drug dealing occurred in Missouri. The court said, venue tracks the prohibited conduct, not the collateral circumstances.
The government counters with three main arguments. The government says Abouammo aims too narrow. Their position, the Constitution requires trial where a crime got committed, not necessarily where the defendant stood. They lean on a 1927 case, Ford versus United States, where Chief Justice Taft wrote that acts done outside a jurisdiction but intended to produce and producing detrimental effects within it can justify prosecution in that second jurisdiction as if the defendant stood at the spot where the harm landed.
You fired the gun in one state, the bullet hit someone in another state theory.
Exactly. And the court has actually endorsed that logic for shooting cases. The government also points to Lamar versus United States from 1916, where someone impersonated a member of Congress over the telephone from a different district. The court upheld venue where the impersonation took effect, meaning where the victim picked up the phone, even though the defendant never stepped foot there.
That's an interesting parallel because Abouammo literally sent the document to San Francisco agents.
That's the government's point. They argue Section 1519 defines what lawyers call an inchoate offense, an incomplete step toward another crime. Think of it like this. Creating a fake document sitting alone in your basement harms nobody. It becomes a federal felony only because of your intent to obstruct a specific investigation. That intent, directed at a specific proceeding in a specific place, makes that place part of where the crime occurred.
Now, Abouammo pushes back hard on that.
Hard. He says intent is mental state. It's not conduct. Criminal law has always separated the evil-meaning mind from the evil-doing hand. Venue tracks where you acted, not where you thought. He points to Johnson versus United States from 1944, a case about mailing illegal dentures for the purpose of sending them into Delaware. The court said, the crime finished when the sender dropped the package in the mail in Chicago. That, for the purpose of language, didn't drag venue into Delaware.
So Abouammo says, my section 1519 offense finished the moment I hit send in Seattle, regardless of where the email landed.
The government shoots one more arrow. Even under Abouammo's own theory, they argue, venue still landed in California. Why? Because when he emailed the PDF to Agent Kingsley, that created a separate duplicate record on FBI computers in San Francisco. Different metadata, different file. So Abouammo effectively falsified a record in two places, Seattle and San Francisco.
So those are the stakes. What does this actually mean for real people?
If Abouammo wins, conduct controls venue, federal prosecutors can only try document falsification cases where the defendant physically acted. Defendants get the constitutional protection the founders put in twice: a jury from their own community, familiar with their circumstances. The flip side, the government says that creates a nightmare. Modern falsification often leaves no physical footprint. Delete the metadata, travel frequently, live near a district boundary, and the government may never pin down a valid venue.
And if the government wins?
The investigation's location becomes a second permissible venue for any obstruction type offense. That has enormous real-world implications. Federal agencies run investigations from specific offices. If the office location determines where they can prosecute anyone who lies to those agents or falsifies documents connected to that investigation, prosecutors gain tremendous leverage in picking their forum. More government-friendly law, harsher sentencing tendencies, a city where the defendant looks like an outsider to the jury.
Judge Lee, the concurring Ninth Circuit judge, actually flagged that concern. He agreed the conviction should stand, but warned the court should stay wary of attempts by the government to cherry-pick favored venues through pretextual reliance on out-of-district agents. He just didn't think this particular case crossed that line.
So those are the stakes. What should we watch for at oral arguments? They take place on Monday, March 30th. Listen to them here at the High Court Report.
Watch for the justices to press both sides on line drawing. If the government wins on intent and effects, where does the principle stop? Can a defendant face trial in any city an investigation touches? What if 50 FBI field offices all receive the same emailed document? And they'll push Abouammo's side too. His rule says conduct determines venue, but what about crimes that, by their nature, require communication with a victim, like bribery or fraud? The bribery offer in the old Palliser case from 1890 didn't become a bribe until the postmaster in Connecticut opened the letter and could actually be influenced.
Right. Abouammo tries to distinguish that because Section 1519 doesn't even require that the document reach anyone. You could create a fake invoice and lock it in a desk drawer and still commit the crime. So the offense finishes at creation. Watch for Justice Thomas, who tends to anchor constitutional questions in founding-era history, and Justice Barrett on the statutory text itself. Abouammo's historical argument that the founders literally wrote these venue clauses in direct response to Britain, dragging colonists to London for trial, lines up with the originalist wing of the court.
The government will counter that history supports their side too, pointing to the long line of cases saying crimes can get committed in the place where they take effect, not just where the defendant stands.
Bottom line, time. Why does this case matter?
Because it defines the geographic boundaries of federal criminal prosecution. Every person who ever talks to federal investigators in a white-collar case, a national security case, anything, now faces the question of where any false statement or false document might send them to trial. And the answer may depend entirely on where the FBI assigned the case.
It also speaks to something the founders cared about deeply enough to say twice: a jury of your neighbors not strangers. The Declaration of Independence literally lists being transported beyond seas to be tried for pretended offenses as one of the specific grievances against the British Crown. Abouammo says the Ninth Circuit's rule gets us closer to that than the Constitution allows.
That's it for today's episode. Thanks for listening. Find us on Apple Podcasts, Spotify, YouTube. Just search the High Court Report. And honestly, subscribe now before any of your documents get subpoenaed. Talk to you soon.